Morning, everyone. We here, you're not going to get rid of us that easy. In the interim, find that discussion we said we'll do a homework, and guys in class are ready to look at it, and we see what we were discussing and how to get there. Okay, so you went through the bear case. What did you find interesting in that case? I hope you can hear her online, because otherwise we'd have to move all the microphone in her face.
Um, and then shortly after that, he fell ill and passed away. And then the according to Black Watch, is it Black Law? Yeah, so the male print law, yes. So the brother inherited everything, and then he wanted to sell everything to pay for the funeral. And
Yeah.
the lady and her kids were basically being cut out of his entire estate.
So it will follow then that the male of the family inherits everything. And therefore, if you are a woman with two daughters, you and the children will not inherit anything. It's only it will now go to the next male, which generally be the uncle. So what happened? How do they solve that problem? So it's everybody is equal before the law. And the Constitution says you may not discriminate a person because of the gender, one of those. And therefore, to discriminate and say women cannot inherit from the estate simply makes it discriminatory for them not to inherit. So as a result, you find that the Bear case has created a situation where females can actually inherit from their family's estate. And I nearly said from their father's estate, but generally it's from your family's estate. That that estate could still be the estate of belonging to the mother or the estate belonging to the father. The children would then inherit from that estate. So that's the essence of the Bear case. It dealt away with discrimination against women. All right, somebody else, what did you see? And I'll shortly, after these discussions, log out so that I can log in using the Paralegal link so that I can share the book. But for now, let's have the discussions. What was the next issue to discuss? The other question which you had to go and deal with? You remember you also had to look at the rules of the court, and you had to find something around what rule? The notice of bar, I think. So what was the point of looking for the notice of bar? The point for looking for the notice of bar was for you to understand the importance of time frame in litigation. Everything in law follows, it's like clockwork. If you're supposed to file documents within 10 days and you do not, what will then generally happen is a default judgment will be obtained against you. But that is if you have not entered a notice to defend. But what happens then if you've entered a notice to defend and say, for example, it says in 20 days you need to file a plea. In 20 days you file nothing. They'll then send you a notice of bar. That's the rule. And the notice of bar will say, please note that in the next 5 days, if you do not file your plea, you'll be insofar as being considered barred from filing the plea, and the matter will continue without you. General sense, and I'm speaking it in general sense. But what then would happen is you don't file in 5 days. The matter proceeds in court as if you have not responded to that matter, and you end up with a default judgment still. So judgment in your absence. So ultimately, it's important that when you work as a paralegal, you need to notice the dates. They call them Dyer's dates. You need to notice the dates that follow, because these dates, they determine the left-hand side of a legal process. Remember, we said the legal process has got two sides. On the one side, and I'm just putting it on the left-hand side is procedure. On the right-hand side is substance. If procedure is not off the blocks, a legal matter cannot proceed, irrespective of what the substance is. The procedure must be right. So if the procedure is not followed, there cannot be the substance. You have been watching the news. Which minister is it a minister even? Which prominent politician is now about to be arrested or something like that in parliament? Yes. Katlo, who? That would be the Speaker of the Parliament. What is her name? Hey, you guys, the only speaker you know is me, you. Mapisa, and the surname Ngagula. And she was in court yesterday, actually. And the arguments in court, find the YouTube on it. The arguments in court, even if you can just find the one that explains the short clip rather than the whole proceedings. But even if you were to listen to the proceedings, they're not too long. The whole argument she's making in court is that she cannot be arrested even if she is a suspect of an offense. And then we all sit and say, how? If you commit a crime, you must be arrested. And she brings in a very interesting dimension that says, arrest is not the ultimate manner to bring an accused before the court of law. There are other methods. You don't just choose arrest. You choose arrest in your normal run of the mill, but in general sense, the other methods, you can actually subpoena the person to come, and the person will come. So she says, do not arrest me. I will come to court. Thanks, Bulelani. I'm coming back to what you've written. It says, do not arrest me. I will come to court. But here's the spanner in the works. She doesn't say I'll come to court tomorrow. She says, my lawyer is not available. He's in KZN. Will come as and when my lawyer is available in the next 2 weeks. Come on, if I stole a goat, they arrest me somewhere now. I mean, really, they'll be on my street and the goat confiscated before I eat the whole thing. But she is now getting the privilege to be arrested at her convenience. So the argument then is it really privilege? If it is privilege, can it be enjoyed by everybody? Can every Tsotsi now say, now, please, I know I've stabbed Simon, but my lawyer's just not here. He's in the Bahamas. Wait, he'll be here in 3 weeks. We will come. I don't think this will work. Can we also say perhaps it should work when the accused is a high-profile person? No, I mean, Jacob Zuma was arrested. And so are the other people. So it doesn't follow. But then again, we're going to hear what the court will say on the 2nd in determining this issue. The point we're trying to make is the procedure, how you arrest a person. It doesn't matter what she has done. What she's arguing is the left. The procedure of bringing her to court, is it by arrest or is it by love letter? So that's why she's asking, that she wants a letter. Dear Honorable Minister, we love you so much, Honorable Speaker. Kindly avail yourself after you pass by McDonald's to come to court. No, it cannot be by love letter, but we will hear. So she is arguing procedure, but on the other side, on the right-hand side, there is substance. Substance is what she's being accused of. And in the very same document, she's asking for disclosure. She says, tell me what I have done. So disclose. And those in practice say, yeah, are you not supposed to appear first? Bail, disclosure. Then we postpone and we wait. We get the papers and we move right along. You want disclosure right about before you even appear, because disclosure it's for the accused. Right now, you are a suspect in a far distance, not even the accused who is before the court. And then we disclose what to you then? Because you've got a right to be informed of the reason why you are being arrested. But for that to happen, arrested must happen. Because that right happens when you're being arrested. You've got a right to umbrella when it rains. But for that to happen, it must rain. It's not a right to an umbrella. It's a right to an umbrella when it rains. So it's arguments that are before the court. And these arguments, you can see they're discussing the left, the substance. Bulalani says, notice of bar, rule 19, 20 days. In 20 days, you need to supply your plea. If you don't supply your plea, you have 5 days. And 5 days, if you do not, will proceed without you. And why is this? This is important because it speaks to the procedure that must be followed when a party is before the court. It doesn't matter why you are there. You might be right. It might be about the money you are owed. It might be that you do not owe that money at all. You've got a very valid defense. But the moment you do not come to court, that defense doesn't apply. You find this a lot in banking law, not really banking law, consumer protection. So what happens is you buy a car, the dealership says there's a balloon payment on the car. After you finish paying, they say, okay, fine, the balloon payment is 50,000. You do not follow up and apply for refinancing of the balloon payment and you dilly-dally. They send you documents. And in most instances, when they send you these documents, they are clandestine about it. They don't send these documents very openly. They don't go to work and everywhere and find you. They just send them as convenient as they can. And the next thing they are in court and they say that he's not here. They get a default judgment. The next thing they get a writ of execution. The next thing they repossess the car. But it's strangely, when they come to fetch the car, they don't send the documents clandestine anymore. They call you, they trace the car, they come to work, they look for you. You see? And you say, but 50,000, I would have paid more. Yeah, you've got a very good defense, but you see, the problem is you have not come to court and communicate the substance of your defense. And as Bulelani says, you had 20 days and you're given another 5 days and you did nothing about it and there was a default judgment. Okay, so that's why you need court rules, and you find it, what we have now looked at is in the magistrate rules, but you also find it in the High Court, the same rule, the notice of power. One more thing we were supposed to discuss before we take a small 5 minutes break for me to switch over to the paralegal textbook. So the other thing we're supposed to look at was the section 35 of the Constitution. The section 35 of the Constitution discusses just what the Speaker of Parliament is alleging. Her rights, the rights of the accused. So I met a situation where somebody says, no, Mr. Pala, we went to your client's place of work. We didn't arrest her. We took her. So they're like a movie, this take care. So how do you take a person? Can that really work? Can you go to a place of work and take a person to the police station? Practically speaking, you arrested her. It's just that the language you're using is very different. So your rights of offenders or the rights of the accused in section 35 of the Constitution would have to be respected when a person is arrested. For example, they've got a right to remain silent. The moment you take them and they say, but you ask them questions, they don't want to answer. You say, well, answer, you are not arrested yet. And then they answer, after they answer, say, okay, I'm arresting you for what you have said. No. You could have informed me that I've got a right to remain silent, and therefore you cannot now come back and say, the only reason of arrest is what you have said. So I've got a right not to give testimony or any evidence against myself. But that's why that very right to remain silent, isn't it? So it's the right not to give self-incriminating evidence, Section 35I there at Bulelani. So these rights are the fundamentals, but you need to understand where you come from with this. You come from a South Africa where the police would arrest anybody nilly-willy. For you to get to where I'm going, because you need a point of reference. Think the Rivonia trial. The Rivonia trial is where Mandela and them were being tried. Mandela and them are the popular suspects whichever came before the court, but there were other people as well. How the apartheid police will do is they'll just arrest you, like Steve Biko take you to an office. Yeah, so he was taken and beat you up, terrorize you and everything. Whatever you say, then they use that against you. So that becomes a problem. To avoid this situation, you now have a constitution that protects you from being arrested without cause. And that is the Section 35 of your constitution. So the Section 35 of the constitution, interestingly, it gives you the procedure of arrest. What should happen? It doesn't care what you have done. It simply discusses the procedure of your arrest and how it should be done before we discuss the evidence, for example, in Section 35I. Still, how that evidence is obtained, there is a language later you will learn that says evidence obtained under duress is not admissible before a court. So those are the other issues that will be discussed. But what is important for you as a paralegal is for you to understand that your client and the client of the firm you're working at has got constitutional rights. And if he's been arrested, he should have been read these rights. They actually make him sign a form at SAPS. And that form tells the offender of their rights. And then they tear a copy of that form and they give him the copy of that form with the right to remain silent, the right to an attorney. Perhaps the right to an attorney helps with the rest of Section 35 because now they cannot put everything in there. But the moment your attorney is there, he will then protect all these other rights which are there. So these were things we had to discuss. Is there any other thing you wish us to discuss before we close off for 5 minutes? Katlaho says, let's look at Section 212, the role of traditional leaders in our constitution. The role of traditional leaders in our law is that traditional law and is regarded and accepted as law only to the extent that it does not interfere with the rights enshrined in the Constitution. So what does that practically mean? That practically means that if they take you to an induna, and induna or Khoshi makes an order, the order of the Khoshi or of the induna is law. But that order is subject to it not being against the Constitution. Of course, the other things like you can then get that order reviewed at the magistrate court. So after the indunas, the next court is the magistrate court. Of course, the magistrate court, the next court is the high court, but the indunas is the magistrate. There's, of course, you having to say, well, let me take this issue because the induna made a ruling about 500,000 rands and the magistrate court cannot deal with that situation. The cattle were worth 500,000. Therefore, this should be a high court discussion. And then you take the whole situation to the higher court. That will be that. But in other general matters of the community, and whose stand is it? Like if you live in if you're like some of us who inherited your grandparents' property in the villages, and naturally you are not from Venda, you just happen to be half Venda. The other And you also have vendor in the big case sense. It's your grandmother who is vendor from your mother's side. But then you tend to inherit from her, and she gives you her property in vendor. But what then happens when you don't go there very often? Can the chief put somebody in that property? Or can the chief allow other members of the community to plow in that farm? No, because then it belongs to you. But what if he did? You can challenge this whole situation, right? So you go challenge it in the courts. If you're from KZN, you're facing the same situation where you're looking at the Ngonjama Trust. If your parents have got a property that belongs to the Ngonyama Trust or that falls under the Ngonyama Trust, your parents pass on and you are left with the property, and now you leave to come to Gauteng for like 2 years, and you go back home, you find that Busiso is now living there. Says Busiso, what happened? He says, well, Induna ite. I went to the Induna, and then the Induna said I must live here. So that decision of the Induna needs to be reversed. And to reverse that decision, you would follow Section 212 that says it should not be against the Constitution. What provision will this be against? It will be against Section 25 of the Constitution that says everybody has got the right to property and not for their property to be taken from them arbitrarily, which means without good cause. So those are the things we needed to discuss. I see it's now 5 minutes to 10. Let's give us a good 5 minutes break. And when we come back, it will be about 10 o'clock. And we will then, at 10:05, start going through the final discussion under module 4 to look at the things we were discussing on Thursday evening on module 4. I will log off so that I can log in as the paralegal facilitator, because I think this is now logged in as my personal login. So I'm not able to share the screen. So for me to be able to share, I'll have to switch over. So when I leave, don't now go celebrating and you buy cricket. Say, yes, school is out. And then you disappear. Come back, we continue at about at 10:05. Thank you. Okay, welcome right back. I'm unable to share my screen from my side, so if Melvin is on, she'll assist by sharing from her side. But I'll also mention the pages that I'm on. We are looking at module 3. The last time we left, we were at about page 11, where it says example of a simple case sheet. That's simple case sheet. If you look at the bottom of the page where it says LSSA, it will be written page 6. If you're scrolling through using Acrobat or something like that, it should be on page 11 of the Acrobat page. So what you're looking at there is an example of a case sheet. So we've drafted a basic, simple one for you to use. I see Melanie is also having a problem trying to share. So we'll go through this old school. So I'll tell you where to go and you go. If you turn left, you're supposed to turn right. You're on your own. So then you're looking at where it says Paralegal Incorporated Case Manager, the date. It's important that you put the date of the instruction there so that we should know when the instruction came. But if you're using an online system, some online system actually have got a client intake with them. It's not all systems that get a fancy client intake. I remember that this one we piloted at the office. It's called My Case. It's a USA system. The client intake is very nice and fancy. The disadvantage of that system is that it bills in dollars. So imagine you have to come to my office for consultation. Then we charge you $1,500. I came from DDA. So that would be a whole lot of money. And now you have to explain to the client, no, ignore the dollar, is the rands, but still, man, my heart is going boom, boom. Dollars. No, you guys, no. So we couldn't use it because of that. It doesn't have the rand sign on it. But also the other reason is it's an American system. It's expensive. It's very expensive to use. But it's beautiful. It works on your cell phone. So it gives you a client intake, and you can simply sit with a client and you type in all these things on a cell phone, then it loads on a file, which makes it quite easy. And I know the other systems do that, but this has been the most user-friendly one I've ever seen. Thanks, ma'am. Yes, I can see coffee is coming my way. I hope you guys had coffee. Thank you. Thank you very much, man. Cheers. And now the situation then is when you're doing this manually, take this sheet and paste it on top of the case file, or if they don't want you to paste it on top, put it inside as page 1. So it makes it easy for us to see what the case is about, who is the client. The identity number of the client, remember last time we said once you get the identity number of the client, it's easy to get the date of birth. If the client gave you an ID number, really don't go asking for a date of birth. The date of birth is built in an ID number. Even the age, if you took the calculator, you should find the age. The telephone number of the client. In old school, you'd ask for their telecom telephone number. But things have since moved right along. The cell phone number of the client is very important. Actually, these days, you want to ask the client whether that number they're giving you is available on WhatsApp. Because whereas the old school law firms would say to you, no, we don't communicate with clients through WhatsApp. Guess who communicates with you through WhatsApp? The very client. They send you a WhatsApp and say, please email me the document, and then you email it, they send you a WhatsApp and say, received. We should have said the whole thing on WhatsApp, boss. So just have that discussion with your office and find a cleaner way to do WhatsApp in the office. Of course, the problem with WhatsApp is it's more of your social media space. The professionalism lacks. What we have done in our office is we have put, you know, you can put WhatsApp on your computer. So somehow, when you type it on a computer, it gives you that sense that it's work. It's unlike when you type it on the phone. So on a computer, you tend to be more refined when you type it, but something like that. The email address of the client, just find what is the email address of the client. And also if they've got an alternative email address, because sometimes somebody's got a work email address, but they also have got a Gmail or something. In most instances, the Gmail ones are the ones that go directly to their phones. So try and find yourself an email address that goes to the client's phone. Type of case, is this a labor case, is it a criminal case? This will depend on your understanding of things. But in offices, we tend to separate them first in the two broad categories. Is it a criminal case or is it a civil case? If it's a criminal case, it's easy. The police are involved. If it's a civil case, the police are not involved. It's just the two parties. Then from civil cases, we can then break it down into different parts. If you're familiar with divorce cases, you say this is a divorce case. But if you're not familiar with whatever kind of law this case is about, you would, for example, if you have an instruction now on restraint of trade, are you going to put it under labor law? Because it usually comes from labor law issues. Or are you going to put it under copyright law? It depends on what you deal with at that moment and who are the parties. Consultations takes it further, but if you're not sure, write the two for me. Say, civil case, Mr. Pala, is about something about copyright from an employment contract. Then I will know where to place it if the person is not working at another company, but he has started his own company and his former employer says he cannot sell the same product he used to sell where he still worked for his employer. Description and details of the client's problem. So you can see there in brackets, we said leave plenty space. Generally, press enter and create space when you do that so that you can be able to type in. If you ask me, limit it to 5 sentences. Go to 10 sentences if it was. If you cannot find in 5 sentences what's the problem, then there's no problem. So it's immediately when a person with a problem, they'll tell you they've got a problem. They'll say to you, my child has been chased away from school. Okay, by who? By the accounts department. Why? They say it didn't pay the school fees. Did you pay? Oh, well. so, so you can find these things. They're easy to find. Description and details of the client's problem, create space. 5 sentences should get us there. Advice or suggestions given to the client. Tell us what you said to the client. This is important because you are talking and I've done this when I was a new lawyer. I used to, when the client comes in and I say to the client, oh, this one, small waters, mangani, we'll solve this problem for you, chop, chop. Guys, there's no chop, chop solving of any problem in law, because law problems, they're like spider webs. They've got issues and issues and issues and issues. When I was doing articles sometime, my principal used to say to me, if you don't remember anything, Mr. Pala, remember these 2 things. One, you are worth 2,500 an hour. I said, thank you, sir. I'll take 2,000. I'll take 2,000. Thank you. What next? And he says, never ever trust the client. I said, what kind of advice is this? Now, when I started practicing, I realized he was right. But I'm actually worth 3,000 an hour. But then again, he was right. Don't trust the client. It doesn't mean don't sympathize with the client. It doesn't mean be nasty to a client or second guess what the client says. What he meant is just take what the client says with a pinch of salt. Because the more you don't know, they're a whole human being. There's other things that might have occurred that they are not telling you. The guy who calls from LSSA says, Mr. Pala, I want you to represent me. Okay, that's fine. You can come to the office for a consultation. My principal said I'm worth 2,500. Therefore, you are coming in for a 2 hours consultation. Be strong when you come. So he says, well, they say I stole the sheep. Okay. And my sister was arrested. Okay. And then the other guys who were there with my sister were also arrested. All right. But the guy doesn't mention that they arrested them at his house, slaughtering the sheep, which were brought there, being towed in a trailer, which was hooked to his mother's Ford Ranger. Where he started, they say, you could have believed and say, ha, Baksugela, Brian. How can they say that about you? He's not telling the whole story. Why do I need the whole story? I need the whole story to defend him. Because, for example, when his sister was released, what did he say to the police that got his sister released? For example, he could have said to the police, you must release my sister. It's not her fault. It's not her sheep. It was my deal. She had nothing to do with it. The police say, okay, write us a statement. Now he writes that statement and he gives to the police. And then enter you, the lawyer who wants to defend him. No. You need to know these things, right? It's important. So what brought us to this story was advice or suggestion given to your client. Paralegal simply advise the client and say, I will refer the matter to the attorney and the attorney would contact you. This road assistance fund say, we have received your files. We will go through them. We will then contact you later if we need any further documents. Do not say, this is everything. Yeah, sure. Aye, pelele la. The next thing you know, you'll have to drive to Matatiel to go fetch the other paper. Because you said it is everything. And if you said we'll let you know when we need some more documents, he will have to drive from Matatiel and bring the other document. You see where the whole thing is. Action taken on behalf of the client. What have you done? I always say to my PA, everybody else in the office, if they mess up anything, they're in trouble. But if you mess up something, I'm responsible. So she's generally allowed to mess up a few things. And if she spends a week without messing up anything, we have a problem. We must take it to the doctor. So this comes from the question, what have you done? Because you'll say, well, I sent an email to the other lawyers and I said to them, how dare you say this about our client? He's a good man. Then what have you done? So as a paralegal, you'll have an edge to feel like you're some mini-me. Because you spend so much time with, especially if you become a PA, you spend so much time with the attorney, you think you're the attorney. And you start giving advice like the way you heard the attorney say it. But the context is different every time. Same situation, but different grounds. Well, bottom of that page, bottom of that graph table I'm reading for you, it's written details of the problem, description of the case. I won't read that. I'll scroll through and move over to where it says in the next page, write down all the details of the problem in the correct date order that things happened. I don't know if I can get you to, let me see. Hold on. Let me see if, my dear friends, I can help you to find, but you will need a News 24 subscription. I wanted to say, let me find a News 24 subscription for you, News 24 article for you about, is it Martin Juste, the guy who killed himself? Marcus Juste. If you've got News 24 subscription, you read through, you'll see somewhere they put a timeline. They say, on this date, this is what he has done. On this date, this is how he went to school. On this date, and this date, and this date, and this date, and this date. How do you take, guys, this is important. We wish we could write it up the walls. How do you take a statement from a client? I'm not saying write an affidavit. I'm saying take a statement. Learn from the police. I used to train the police and taking a statement is a numbers game. It follows dates. Say, when did the situation occur? He says on the 10th of February. Then the next question is what time? And they'll give you the 10th of February at about 12 o'clock. Are you sure? Was it like after lunch or before lunch? No. It was after lunch. Definitely, this is not 12 o'clock. Things have moved along. It should be about 2 or 3. So then you are better writing in the afternoon. Then what happened on the 10th in the afternoon? The person explains. Okay. And then what happens next? He says, then in the evening of when? Well, in the evening of the 10th. So you write the 10th in the evening at about what time? Well, as I can recall, Isivaya and Generations and Uzalo were on. That should be not after 10 o'clock at night. So you write in chronological form. And then what happened? Well, after a few days, he called me again. After how many days? 2 days, 3 days, 1 day? If I can think, it was about 3 days. So you can calculate 10, that should be around the 13th. You say, check your phone. Do you remember who you called or who you WhatsApped or any other thing? You know what you're looking for? You're looking for a date stamp. If they call somebody or they WhatsApp somebody, those WhatsApps and things will have a time and date on them. So you're writing everything in a time format. As you can see there, 25th December, 6th of January, 7th of January. I'm reading from the book, 20th of January. You can see this is a time frame. When you take statements from people, take events in chronological order in terms of time. Why? This is important because when we are going to when we are going to write an affidavit, you can see now example of the statement, and we move over to the other side where it says example of an affidavit. Can you see they almost look alike? And if you're scrolling through, it's on page 14. If you're paging through a book, it's on page 9. They almost look alike. And the very key thing you see about it is the date stamp, the time, the time, the time, the time, the time, the time, the time. Everything else may change, but the time will always remain. That is why there's a good saying that says, only what will tell? Only time will tell. Time always tells a story. How did they determine paternity in the old school days? Time. Huh? If it is 18 months after, I don't know when did. I don't know if this is your child, but it is 8 months. Yeah, the child could be premature or other things, right? But time is important. It tells the story. When we talked earlier, we discussed even about the rule 19, and we said this rule gives you 5 days because you had 20 days. Time tells what happened. Later, I'll talk to you about drafting things. I think it should be in this book and in a later book. You realize that when we draft, all we are doing, we are not telling a story. We are writing a time machine. We tell things according to time. When did the car accident occur? Where? If it occurred on the 20th of January, 2024, Pretoria Central, what time? About 12 o'clock noon. We know there was load shedding. And then we know then the driver who is yacht line who got injured in the car accident is not entirely negligent, because it could have happened that because of load shedding, the traffic lights, hey, you're in South Africa, the robots were not working. And then there was an accident and he got injured, because the road accident fund does not pay a negligent driver. Now, to protect your client, we know that that time it was load shedding, but it was raining as well. Can you see? So all these things, they would have played a role into why there was this car accident that injured your client, who was who was the driver in the car, who lost control, hit a wall, and he can now claim. But these facts are important to assist us in determining that claim. If these facts are not in place, he is just a negligent driver who was busy on WhatsApp, and he cannot claim. So those are the things that when you sit, you listen to a client, you need to take things according to time. And in most instances, we don't usually meet the client firsthand. You meet with the client. I've done, did I say one of the huge cases? I've done this case where people claim land. They come to our office and they sit with us about 3 hours, telling us what happened. We write an affidavit and everything. Yeah, okay, it's a land claim. But something happened. We took the old man, very old, he shakes when he writes, to a police station to commission the affidavit. On the way to the police station, small chat, the weather, the people, the villages. We come back, he starts telling of how he grew up in that farm, the land, who died, who got buried where, who buried them. Suddenly, that affidavit we signed, it's nothing. The true and proper affidavit is the one that's now happening in the car. Interesting. People tell you the full story when they are relaxed. And when they drive with you, you fetch them to bring them to our offices as a paralegal. They tend to be honest. They open up and they tell you the real story. But when they come to the office and they sit in front of the attorney, they somehow close up and tell a clean story. You want somebody to give you the full story. If they gave you the full story, remember they're covered by privilege. If they gave you the full story, you can defend them. But if they gave you a sanitized story, when we go forward, somebody will bring the true story. So you want somebody to give you a full version. That is why it's not easy to represent a client you don't know. If I ever do a criminal case, I want to come to your house and eat your food. Sit down with you, you cook, we talk. Meet your children, have braai, see your friends, let you drive. So that I get to know you. Then you say, okay, what happens? Nah, no problem. Forget it. Are you a Sundowns fan? If you're a Sundowns fan, the better. Let's go to the game. Only then, after a while, we're now writing your defense story. I want to talk to the tea lady. I'm not interested in the directors. They'll tell me a beautiful. The juicers will tell me a juiceful story. They are juice demos. But the tea, you saw her. We study her and ask Mamzo, she will tell and tell and tell. So I always ask for coffee when I come to the company. So what can we offer you? Coffee. If you bring the coffee, say no. Can I have the milk warmed up a bit? I know you're not gonna do it. You're going to get somebody to do it. When that person comes, I say, what's your name? Then I'm interested in the cleaners. I go to the bathrooms. I come too early and I talk to the receptionist, we chat. That's the true company. I've dug good companies out of 9 million rands of holes and things. But the people who helped me were not really the directors. It is the cleaner who says, hi, Mr. Pan. Give me a quiet one. It is their way. This is what they always do, these guys. What do I know? I'm a cleaner. Let me go, Mr. Palace. No, thanks, Ausmir. Make me another cup of coffee. Then I'll say, guys, you usually do this type of transactions. Yeah, we didn't want to disclose that, Mr. Palace. Okay, give me the other 3, 4 ones you have done that almost look like this one. So that I can dig you out of your habit. That's contract law. It's habitual. The things you do informs contract. So you need the date stamp of things. You say, so you mean you investigate the beauty of things is I actually studied investigation, so I investigate first. So if you are ever going to work with clients, relax. The other day in class, we talked about different languages. Learn the language of the people. If you are representing an employee, don't let that employee come to the office and say, "Hi, good afternoon, I'm Mr. Pala Martinez. How can we assist you today? Let's see your contract of employment." Hey, who, me? No. Go show me, brah. Did you get any coffee, something stronger? Then he like, hey, Mr. Pala, six-nyana. Hey, mara remorse pani. And then he starts to talk. Hey, one that day I really didn't go to work, Mr. Pala. Hey, and I went to that lady and I bought the sick note. Wow. But Brian told me where to get it. And then you need to plug the holes. When I speak like that employee because I know the story. But if I only know the clean version of things, I don't know the story. Advising the client is what appears next. You see, I'm saying to you, investigate. Listen to people. Don't hear them. Hearing a person speak is one thing. Listening is totally another thing. There are details that they've put for you and the examples I won't go through, but I'm going to leave you with this Soshanguve slang. They say I think it's in Pretoria in general, they say, Meibra, you must make sure. Whatever you say, it must be make sure. If it's not make sure, Brian, it's not going to work. So you want to assist a client, you have to make sure. Learn this terms and conditions apply. Learn this from a serial winner. People who always win. This is the secret behind the whole story. We care. If I don't know you, I don't do your case. The same as a paralegal. If a client walks into the office, know that client. If you don't know that client, don't bring him to me. Why? Why bring strangers? Don't tell me his name is Theophilus Kumalo. Yo! No, say, hey, get doctor, man, doctor, 16 video minutes, man, what cheap, see. Yeah, you see, now we're talking. Dr. Kumalo is very different from Theophilus Kumalo. Dr. Kumalo has got Shibobos written all over the whole situation. So you need to know the client. You know people by listening to them. And when they are talking, they will tell you. And then he said to me, hey, doctor, Skyira died, then don't do it. He said, okay, so your name is doctor. Yeah. So what happened with Theophilus? Delete. So my brother, doctor, tell me. Listen to people. We've given you an example there. And we say to you, sometimes when a client comes to you, they do not need to litigate. All they need is an advice of how to do it. And sometimes, I've given examples. There's also example B on page 16, is page 11 if you're paging through a paper book. What I want you to do is when you listen to a client, and this is a note to myself too, do not hear the problem, but hear the solution. There is you guys, YouTube, they should start charging, or maybe I must just have a channel. I must just have a channel. Maybe I'm advertising these guys to people's things so much. So I should actually have a channel so that I can make some money. If you can go, you don't have to get the whole episode, just get something small. There is on YouTube, there should be a clip on BULL, the American series Bull. In South Africa, that thing doesn't work because we don't do our criminal justice system that way. You can also get it. I don't know if they have it on Netflix. I'm not sure. The series, yeah, Bull. It says solutionist thinking. That's where I'm going with this. So it will teach you to think solutions than problems. A client comes with the problem. But if we are sitting, you're sitting this side of the table, you are the solution. The client is sitting that side of the table, is the problem. So the client tells you the problem. Hear this, listen carefully so that you can find a solution and say, okay, so we've got 5 attorneys that deal with land claims. You say you've been evicted from your farm. Yeah, you've been working there for your boss for many years. Yes. I think you need to speak to Mr. Pala because he has done a case like that before, and he assisted an old lady, Mama Shangu, what. There are 5 lawyers, but the other lawyer has done the restitution of a big farm, and he has not dealt with a lady who lived in a farm. So you're not really finding them a solution as in law, but you're already finding them a solution. If you send them to the right lawyer, they will be assisted. Sometimes your law firm consists of different attorneys. Again, I've said, study people. Learn what cases these guys do and how they fare in each and every one of these cases. Even if they are road accident fund clients, there are certain people who gel with certain people. If you hear that this client is very picky, and find a person who's patient in the office. Don't bring them to a person who's not patient. So find a solution. The solution that you are driving here sometimes it's not a legal solution. Mostly it's not a legal solution. It's a practical solution. And that's why a paralegal. You want to bring our client ultimately into a legal solution through the right channel. In our office, we say there's 2 groups of people. Actually, I've got 3. There's these 3 groups of people. You want to talk corporate law and procedure and processes. You go talk to Mr. Malemani and his crew. Yeah, they'll probably go and type rules and follow the rules. You want somebody who talk nice to a client, check whether they've emailed the copy of the ID and things. Talk to Mr. Quinda and his crew. We actually call them the social worker lawyers. So talk to those ones. You'll see Mr. Quinda was here the other day. It's the social worker lawyers. They are nice. You saw Mr. Keith and Mr. Maleman was here, but you saw Mr. Keith. It's nice lawyers, suits. And you want violence? Come here. No. Yeah, there will be violence. Shame. ID, what ID? It will follow, man. What is the issue? See, so you don't want my kind of lawyer holding that funds, eh? Because I don't care whether that person has submitted an ID or not. What ID? You can see them. Don't you believe this guy is South African? Let's move right along. Was there an accident or not? He will bring the ID. How? He will bring a passport. So in your law firm, learn who's violent and who's not, and who's calmer, who is it goes with personality. And they always say, the smarter the people, the less patient the people. So learn, those lawyers always win cases and do well. It's either they're not patient or they're arrogant. You have that problem about them. So when you take a client who needs somebody who's calmer and nicer, family law, like one of our attorneys came because and she says, Mr. Pan, you know, there's this lady, ne? Her and the husband, some 8 years ago, and the husband took half share of the house. And now he says, after 8 years, he wants her to sign the marriage certificates again. After he took the half share of the house. Yeah, and then those 8 years ago, they say that he called the family and told them that they are separating. Okay, so how were they married? Well, it was lobola and everything, but he also called the family to tell them that they're separating, and he insisted on taking half share of the house because the lady was working and he was not working, and therefore he saw an opportunity to make money. And now, probably the lady is doing well. He now claims, no, we didn't officially divorce. For us to divorce officially, you must now sign the marriage certificate in court and confirm the marriage. And the lawyers have been sending this lady emails and harassing her to come. This must be done. She's officially married. I cut the lady short. I said, Bab, where are they? Bring those lawyers here. Bring that guy here. I'm going to write letters first and tell them I don't care. For all I care, 8 years ago, the moment they shared the estate and divided into two, he took his half share of the estate. Divorce. What we are sitting at is divorce not confirmed. And the party who would have confirmed it, it's him. Because he was divorcing and he has now squandered the money and he didn't finalize that divorce. He now comes to my client. We are so finalizing the divorce on his behalf and charging him for the cost. Mike S. So you see, in that kind of setup, you don't need the lawyer who, like my colleague Tembi, who will say, yo, Mr. Pan. Hey, my heart goes out for this late. What heart? With me, there won't be hearts here. There'll be fireworks. Starting from the very first email. Yo, I can see the letter I'm typing in my head. It will end in tears. So sometimes you need those bulldog lawyers. Sometimes you need to stay, yeah, who are more calm. Abantu bashonelwe, there's a funeral. She needs to help them to complete the deceased estate. You don't need Mr. Pala, the deceased estate. No, people will feel the funeral twice. You need calmer people through this whole situation. You need the Mr. Quindas and the Tembis and them. They are our social worker lawyers. They are nice. So when you do consultations, what brought us to this story is know the lawyers in your firm. And if you've got your own practice, have a group of lawyers who you refer the matters to. Know the difference. Lawyers, we know advocates. And then we know that that one can handle this type. That one can handle this type. That one is too sweet. That one is too rough. And no, that one is very clever. Because what we now need is to argue the law, not the facts. So you need a bookworm, somebody who will go and research this thing. So even with the lawyers then, as paralegals, if you're going to refer these things to the lawyers, you need to know who they are. To refer the client to a lawyer. But if you're going to refer the client to a lawyer, can you see information or support which may be assist the client is identified? Each case is unique. So when you listen to a client, do not say, so get divorced, wala. Is this a divorce? Say yes. You say, I know. Don't worry, I know. Bring the. Divorces are not the same, man. There are different issues you have to deal with. If it's normal things, everything will run smoothly. But sometimes things are just not normal. Like you get people, I've told you of the lady in court who cried. 2 years they've been trying to get to divorce this guy. Me, 2 years. For what? Trying to get a settlement agreement. What settlement agreement? Notice of set down. We go to court in G. We go and air our dirty laundry right during the people. And after a few questions, you'll beg me for a settlement agreement. You see, that's the thing. It depends on who you're dealing. Who's got the patience to get your client to divorce for 2 years? No, I'm not gonna do it. So for me to help your client, I need this full statement. If there's an affidavit, I need one. But please, as a paralegal, do not get your clients to write affidavits, depose them, and give them to the other parties. Don't do it. Bring your client to an attorney and let your client write a layman's statement and repeat that layman's statement in front of an attorney to assist to write an affidavit. In some instances, attorneys don't even write the affidavits. There are some other affidavits, after we write them, we take them to an advocate to settle. Settling is check and make sure it's correct. Because affidavits are evidence. They might admit things which your client did not intend to admit. And you therefore need another eye to help you to see. Sometimes when you write things you don't see. Oh, it's by the way, it's the same as this. When you write a letter, when the attorney in your firm said write a letter, you try to proofread the letter on the very same Microsoft Word you wrote it. Trust me, it's not gonna work. You'll miss the very same comma you missed. Solution: print the letter and read it. But save time, don't print the letter. PDF it, send it to your WhatsApp, read the PDF. It reads very different from the actual Word document on your computer, because it's away from where you have actually created it. Then you will see a totally different perspective. And we always say, after you write a letter, go and make a cup of coffee and come back. And then read the letter. Don't read it in the same Microsoft Word you wrote it. Read it in a different platform. Read on your phone, read on an iPad. If you don't like trees, print it. But generally, it takes you away. What I'm saying is affidavit is the same. Don't get an affidavit commissioned unless you read it tomorrow, unless you give it to another attorney, unless it goes to another lawyer, unless it goes to another paralegal. Do not finalize the document before you've got a second pair of eyes looking at it. It's very, very important. Get supporting documents, get photographs, get information obtained from experts, if any, and make sure that the expert is an expert. Is qualified to be an expert. That's what we are saying. Get facts from the library. There's a missing bullet there. Do not get things from ChatGPT. Please don't do it. Don't Google it. I've talked, another lady calls and he says, Mr. Pala. It was very early in the morning, so I haven't had my first cup of coffee, so I was not really in a very good mood. Mr. Pala, this matter, it must be settled and your client must pay. It is 7:30 in the morning. So where are you calling from? I'm calling from a debt collection center. But then the money has already been paid. This is the first thing. Secondly, which means you have not conferred with your client before you called me. But secondly, it's 7:30. It's not business hours. You generally are calling somebody out of business hours. Just, hi, Mr. Pala, 7:30. It's business hours. You can Google it. Ouch. Now the conversation went south very fast. Google what? Really? Google it. No. Here's the act that says it cannot be done. Don't tell me to Google it. So please, as a paralegal, you might also work in call centers. Please don't tell people to Google stuff. You might sound very fancy impressing old ladies and old timers and also gents and ladies. Okay, I'll Google it and check then. No. If you Google it in Explorer, it will tell you a different answer. You Google it in another Safari, it tells you a different answer. Google another. No, 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 no. Authorities must come from the rightful place, from the acts, bylaws, regulations, textbooks, articles from recognized journals, and court cases. If you work with us, please subscribe to Deribus, the magazine that the Law Society uses, publishes. Plagiarize away. You will find a lot of articles about things. At least the people writing there are people of authority. They know what they are. But don't just also take them for their word. Read the context from where they're writing this thing and research further. It's very important. But at least you're starting this at the right place. Learning outcome 2 is next. We will not do learning outcome 2. Next time we come, we'll then look at the 4th book, Information Communications Technology, and we see how information communications technology goes. We are at the end of today's lesson. You have another 5 minutes to ask questions on the chat box, or you can unmute yourself and ask a question and have a discussion. Today's lesson, you have noticed it was more of what happens in real practice. So you're going to hear me have this discussion with you a lot on what happens in real practice. Because what we want you to do is go back to the law firm and add value. And if you're running your own paralegal practice, run a paralegal practice that lawyers love. Because when we get a case from you, we get a clean case from you. All right. In the class, any questions? In the chat groups, any questions?